for that very generous introduction. And thank you for organizing this conference and to all of you for attending. I'm going to get into this a bit, but at the outset I'll say that constitutions at the end of the day are really just ink on paper if we don't care about them. And fundamentally, I think what differentiates a free society from an unfree society, one of the things that does, is an engaged citizenry. And just by coming today and yesterday, by taking part in this, you are being an engaged citizenry. You are buttressing the rule of law and buttressing Canada as a free society. And I think that's wonderful because, like I'm saying, culture, civic culture, is really what will protect Canada in the long run, I think, from devolving into an unfree or a populist run kind of society. So I'm here today to speak about the rule of law. And right off the bat, the question is, what does that mean? Lots of people have given different answers about what that means, and I don't think there's anything close to approaching a consensus on what it means. But I think fundamentally the rule of law has two important principles. One is that laws must be known beforehand. We see this every day in our lives. When we're driving on the street, we see the speed limit that says 50 kilometers an hour. We know beforehand, if I go more than 50 kilometers, I could get a ticket. If I go 50 or less, I won't. Imagine if there was no speed limit except that police could pull you over if they just didn't like the way you were driving. You would have no way of knowing how to conduct yourself. You may be able to go 30, you may be able to go 100. It would all be up to the arbitrary discretion of a police officer to say, you know what, I don't like the way you're driving, so I'm going to give you a ticket. The rule of law says that citizens must know the law, or must at least be able to learn what the law is. The second point that is related is that everyone is subject to the law, including and especially state actors, the government, whether it is the executive, the legislative branch, and the judiciary. And I'm going to talk about that, and if I have enough time, get into how the judiciary and the rule of law relate to one another. The rule of law is ultimately about process. It is not the rule of good laws or just laws. And that's an important point that we need to keep in mind at the beginning, that the rule of law is necessary to a free society, but it is far from sufficient for a just or free society. What the rule of law guarantees is institutions and processes. It says that the people who enact the laws should be different from the people who carry them out, and they should be different from the people who interpret and apply the laws, the judges. And that's so important because if the same state actor is the person who writes the law, executes the law, and then interprets the law will become whatever that state actor decides the law is. And there's a very famous British case from something like 1305, 1315, something like that, where a lawyer is appearing before judges of, I think it would have been the Privy Council or King's Court, some very flashy sounding name like that, and arguing about what the law means. And the judge says to the lawyer, "Don't tell us what the law means. We know what the law means. We wrote the law." And that right there is the fundamental rule of law problem for why we have a separation of powers and an independent judiciary. Because if the judges are the same people who carry the law out and who wrote the law, judges can say, well, the law means what we want it to mean, and we're going to carry it out the way we want it to mean. So that's why it is so important to have a separation of powers. But there will always be a temptation for any of these state actors to ignore the rule of law. And this is the fundamental tension we see today across the Western world, but I think historically in all free societies. And this tension arises not because we're confronted with evildoers who want to tyrannize the population. Very often it's the opposite. It is do-gooders who want to do what's right, what they believe is what's right. Because the rule of law, like democracy itself, can be very cumbersome and inconvenient. It's slow. It doesn't say we'll give you a good outcome right away. It says we will give you institutions, and in the long run, that will generate good outcomes. So it's understandable why state actors would want to say, you know what, we have these laws, but I think this is just wrong, so I'm going to do X instead of what the law requires me to do. It's an understandable impulse, and it's an impulse that I would submit is felt by every branch of government, but it is ultimately corrosive to freedom, to a just society. Because when you do that, what you really do is you set a precedent for the arbitrary use of power, you set a precedent for lawlessness, you foster a culture, again, a civic culture that is okay with using arbitrary power. And in the long run, what that does is it allows someone with powerful ambitions, which is usually not going to be someone who's looking after the public interest, to wield that arbitrary power in a manner that you will not agree with. And so while the use of arbitrary power may seem like a great thing in a particular case, it may be exactly what you want done in a particular case, in the long run, what you will get is arbitrary power that is used in ways that you fundamentally disagree with and that are fundamentally unjust. The problem is that, as Peter alluded to, we can all disagree on what is just. Aside from very obvious things like slavery, like genocide, there are no obvious answers to issues of immigration, taxation, abortion. These are contested values in society that you may think are obvious, but if you walk down the street, step out of your bubble, speak to people you don't normally speak to, you'll find that these are heavily contested issues. And what the rule of law says is that we will deal with these contested issues in due course. We will deal with them within a structure that allows for democracy to flourish, for minority rights certainly to be protected, but ultimately within a fixed structure where the correct outcome, quote unquote, will emerge only through the fullness of time. History has borne out time and again the danger of ignoring the rule of law in favor of what we might think is a just outcome at the time. We can see this in the differences between the American and French revolutions. The American Revolution was far from perfect, obviously, and the United States was far from a just society and still has many kinks to be worked out. But fundamentally, the American Revolution was a rule of law revolution. The American Constitution is the founding document of that state. And right from the start, the idea was that the United States would be a government of laws. And that fundamental structure has allowed the Americans to tackle various issues of justice slowly, but it has allowed them to tackle those issues over time. The French Revolution was about throwing away those old institutions, moving right toward justice. And what happened was that the French, because they said effectively, let's not worry about our institutions, let's go right to justice, what we saw was the terror. We saw thousands of people imprisoned, murdered, culminating with Napoleon Bonaparte taking over power. And so it's a great historical example of when you go for justice at the expense of law, you often end up with neither. And this is the problem on a different scale that we're seeing across the Western world today. We live in an instant gratification culture, and increasingly it seems our citizenry want results that are achieved in that manner as well. And we've seen this in Canada to some extent, thankfully not to a great extent, I would submit, in the area of criminal defense, in the area of criminal trials. Why do we need to give the murderer who is caught on tape going into the building, who's holding the bloody knife, whose fingerprints are all over the dead body, who has the motive. Why do we need to give that person a fair trial? What is the point? Just lock them up. Why are we using state resources? Why are we giving them the presumption of innocence? Well, we do that, again, because we must put the process ahead of the result. And in Canada, what we've been seeing recently is that there are calls, both on the left and the right, to expedite the criminal justice process, to say, well, why does this defendant need the benefit of these defenses? We need to look after victims. We need justice. I would submit that is an incredibly dangerous proposition in the long run, though it could produce good outcomes in individual cases. So the question becomes, how does the judiciary intersect with the rule of law? Well, it is one branch of the state, and it's an integral, the judiciary is perhaps the most important branch of the state to protect the rule of law, because the judiciary is really the last line of defense against breaches of the rule of law by the other branches of the state. It's unique from the other branches of the state, too, because the other branches of the state can refrain from acting, and by doing so, they can not violate the rule of law. We may have very bad laws that are enacted, but if the legislature doesn't do anything, it won't breach the rule of law. If the executive doesn't do anything, it won't breach the rule of law. The judiciary is the only branch of the state that must act in order to protect the rule of law. But the judiciary must not go too far, because judges are state actors, and they are bound by their role to interpret the law. And that's a very difficult job that judges have to do, because on the one hand, they cannot do too little, and on the other hand, they cannot do too much. I call this it's the Goldilocks approach to judging. Can't be too hot, can't be too cold. In the realm of administrative law, I would submit that on occasion, we've seen judges, and in constitutional law, but in the realm of administrative law, essentially, we've seen judges, in my respectful view, sometimes act a little too deferentially. Judges must protect the rule of law. If a legislature enacts an unconstitutional law, that law must be struck down. That is the judiciary's role. If an administrative actor acts outside the bounds of what a statute says they can do, that administrative actor's decision must be overturned. On the other hand, sometimes we see judges, and by the way, I want to preface this by saying I think almost all of this is done in good faith, and reasonable people can disagree about this, but sometimes we've seen judges go too far, striking down laws that really didn't violate the Constitution, but rather violated what some people think the Constitution ought to say. I think for the most part, judges strike the balance quite right and work very hard at doing so. But it is extremely important that the independence of the judiciary be a two-way street, because judges are the last line of defense. It is so important that the other branches of the state do not interfere with the judiciary. But the converse of that, the corollary, is that it is so important that judges do not interfere with the other branches of the state. That judges interpret laws, they do not legislate, and that they do not let executive actors or the legislatures get away with things they shouldn't be allowed to get away with under the Constitution. It's a fine line to walk, and I think it's one that in this country our judges have walked very well historically, and it's one of the principal reasons why we have weathered to date this populist storm. One of the reasons. So I would just close by saying that history has shown that if we ignore the rule of law in favor of what we may think of as a just outcome, we will end up with neither. But it has also shown that if we respect the rule of law and follow the rule of law, we will end up in the long run with both law and justice and freedom. I'm hopeful, because of conferences like this, that we will continue on that path. And I think that if we all remain civically engaged, if we all think about the importance of our institutions, the importance of fostering that rule of law culture, then I do think that most issues will take care of themselves in the long run, that we will not have to fear this populist uprising that has occurred in other parts of the world. We will remain rooted to our historic traditions and to freedom, equality, and liberty under the law. Thank you.